Okay, so I'll be walking you through a fairly brief slide presentation on the private surface agreement registry. Jessica and I have been and Keely and I have been working on this for the last year to get it up and running for November. So I know there's probably going to be some questions on this after, but we'll walk you through through some of the details and go from there. So the Private Surface Agreement Registry was introduced in the Responsible Energy Development Act, and the section of the act that deals with the registry was proclaimed on November 30th, so we're just getting into this now. The purpose of this registry is to allow landowners and occupants to register private surface agreements with the AER. And then if a company feels that, or sorry, if a landowner or occupant feels that a company is not meeting a term of a registered agreement, they can request that the AER intervene. So in the Act, a landowner is defined is as defined in the Land Titles Act, and occupant is as defined in the Surface Rights Act. It's long definitions, so I'm not going to get into that now, but you can look up to see what those definitions are. So in terms of eligibility for the registry, there's a couple sort of key pieces you need to meet before you're able to register, before a landowner or occupant would be able to register an agreement. The first one is that only written agreements ratified after November 30th are eligible and will be accepted by the AER. So anything signed prior to that is not able to be registered. And that comes straight out of the Responsible Energy Development Act, that provision. Additionally, only agreements between the landowner or occupant where energy activities are located or proposed to be located are eligible to be registered. So that means that a neighboring landowner or occupant is not eligible. So it has to be an owner where either a pipeline, well, facility, access road, things like that are actually on their land. However, certainly we understand there could be disagreements between neighboring parties and a company, so we would encourage those parties to pursue other avenues, including ADR and avenues such as that. Any Albertan can still call the AER for all concerns relating to energy development, and we will deal with them. They just may not be eligible for this particular registry. So to register a private surface agreement, owners or occupants must fill out and submit the PSAR registration form, which can currently be found on the AER website. We will review those forms to make sure that it has all the information we require and to ensure that they are eligible to register their PSA. So if we get a copy of a PSA that is signed prior to November 30th, we would not register it. We'll send it back to that individual. A copy of the PSA, once it's determined it can be registered, will be sent to the company that is party to that agreement. So if you as a company have signed an agreement with a landowner who registers, you will be made aware that that owner or occupant has registered their agreement with the AER. One really important thing to note is that there is no review of the PSA content at the time of registration. So we are doing a very basic review of the agreement just to make sure it's eligible to be registered. But registration does not equal enforceability or that we would be able to make a determination on any individual term or condition of that agreement. There is no assessment done of that agreement at the time of registration. So that's an important note. So another piece of this is the Freedom of Information and Protection of Privacy Act applies to all registered PSAs. So that means any member of the public may request a copy of registered PSAs, and it would go through the standard FOIP process, and it may be released under that provision. So the second piece of once an owner has registered a PSA is that they may request that the AER issue an order to comply if they feel a term of the agreement is not being met. So that's, we're calling that a Section 64 request, and Section 64 is just the section of the Act that allows an owner or occupant to make that request of the AER. So as with the PSA registration, there's a Section 64 form that must be completed and submitted to the AER. A private surface agreement must be registered prior to making a Section 64 request. Now, those two things can happen at the same time. An owner could send in a copy of their private surface agreement and a Section 64 request at the same time. We would review the private surface agreement first to ensure that it was eligible to be registered. Once it was registered, then we would register the Section 64 request. Once we received a Section 64 request, we would contact the company. They would get a copy of the Section 64 form, and we would ask the company to respond. The AER may request additional information from either party. We may investigate in some manner. We may do site visits. There's many routes we could take. And all necessary forms and materials regarding a Section 64 request are found on our website as well. So once we've received a Section 64 request and received the company's response and any other information, we will review all the information provided to us, and we will make a decision based on that information provided. Now, one of the things we want to emphasize, the private surface agreement registry is one of many tools the AER offers to landowners who may have a disagreement with an oil and gas operator. Landowners still are able to file a general complaint with the AER, which the local field center would respond to. Landowners may still request alternative dispute resolution, and we may use that tool to resolve disputes. And as part of the Section 64 process, we may require ADR to be conducted to try and resolve that issue rather than having the AER make a decision on it. The outcome of Section 64 request, though, is that the AER may issue what the legislation calls an order to comply. So that means that if the AER determines that a company has not lived up to a term or condition of an agreement, we can issue an order requiring the company to comply with that term or condition. But that is only one of three outcomes that can come of a Section 64 request. So as I mentioned, the first would be if we find that the company has not complied with the term or condition, we may issue an order to comply. There's also two outcomes where a Section 64 request could be closed. The first is if compliance with the term or condition is achieved during the process of a Section 64 request. So if the company is made aware that a term or condition hasn't been met, they may just go out, do it, and that would resolve the issue. The other piece we can do is close it because we determine that the Section 64 request had no merit. So that can be as simple as the landowner suggested that a term or condition wasn't being met, but that term or condition isn't found in the agreement, so there's no merit to that particular request. And I think this is my last slide, actually. So for relevant documentation to review, Part 3 of the Responsible Energy Development Act is the key part of the Act that outlines the private surface agreement registry. Probably the more detailed document that you would want to take a look at that really talks about how this will work is the Enforcement of Private Surface Agreement Rules. Those were released in November, and they are available on the AER website. We've also developed an NRFAC, which I think was out on the table when everyone walked in, called How to Register a Private Surface Agreement. And that's geared specifically to landowners, instructing them how to enter into this process and what this process will look like. And I think that's all I've got.